In a landmark decision, a federal court has ruled that parts of Michigan's sex offender registry law are unconstitutional. The case, Does v. Whitmer, may become a national turning point in how courts view registry laws, particularly when those laws are applied retroactively and without regard to individual risk. The implications for Nebraska are real and immediate. In October 2024, U.S. District Judge Mark A. Goldsmith ruled that Michigan's 2021 amendments to its Sex Offenders Registration Act, SORA, including the retroactive extension of registration terms to lifetime, violated the ex post facto clause of the U.S. Constitution. His ruling focused on individuals whose convictions predated July 1, 2011, determining that extending their registration retroactively imposed additional punishment not authorized at the time of sentencing. In March 2025, the court certified the case as a class action, meaning that thousands of Michigan registrants are now affected. Judge Goldsmith also struck down provisions that required reporting of internet identifiers, email addresses, screen names, etc., finding that those mandates violated the First Amendment and lacked a substantial connection to public safety. The judge ordered the state to delete previously collected online identifiers and issued a permanent injunction blocking enforcement of these provisions. Like Michigan, Nebraska expanded its registry law through sweeping amendments in 2009, making registration offense-based rather than risk-based, and applying these changes retroactively. Nebraska now mandates public notification and lengthy registration, 15 years, 25 years, or lifetime for most individuals, regardless of actual risk to the community. But Nebraska does not require online identifier disclosure, thanks to a 2012 ruling by U.S. District Judge Richard Kopf in Doe v. Nebraska, which found that such provisions were unconstitutional. As a result, Nebraska's registry is slightly less invasive than Michigan's in that narrow area. However, other constitutional concerns remain, especially around retroactive application of registration term extensions, lack of judicial review or individual assessment, lifetime registration with no clear pathway for relief, punitive effects of public shaming, and exclusion zones. The Does v. Whitmer ruling in Michigan provides a roadmap for Nebraskans who want to abolish the state's registry laws, either through litigation or legislative action. A federal court challenge is viable. A carefully prepared lawsuit in federal court could challenge Nebraska's retroactive registration regime under the ex post facto clause, using Does v. Whitmer as persuasive authority. While the Nebraska Supreme Court upheld the 2009 law in State v. Worm, that decision did not settle the federal constitutional question. A successful federal lawsuit would likely need to identify plaintiffs whose registration terms were extended retroactively, document the burdens and penalties they face today, show that the registry operates as a form of punishment. Regarding the legislature, Nebraska lawmakers ought to just abolish the state's registry. It causes harm and protects no one. Some other sensible ideas. When a person has been offense-free and on the registry for 10 years, remove them from the registry. Eliminate public notification. End automatic retroactive extensions of registration terms. These changes would not only reduce the risk of litigation, but also align with best practices recommended by public safety and behavioral science experts. On public advocacy and education, advocates and community groups can use the Michigan decision to shift public perception. The registry has long been marketed as a public safety tool, but mounting legal and academic evidence shows that blanket registration policies do not reduce crime and may even increase recidivism by isolating and destabilizing people. Nebraska's sex offender registry laws are now on shakier legal ground than ever before. The Does v. Whitmer ruling has opened a constitutional window, and Nebraska, with its retroactive, offense-based, and often lifetime registration requirements, may be next. Whether through the courts, the legislature, or public advocacy, now is the time to push for a smarter, fairer, and more constitutional approach.